Hi all, I'm Josh Hale. I am surrounded by a bunch of really smart folks that are also in the world of law and world of tax. We're going to be discussing basically some of the things that happen in crypto, both the like regulatory pitfalls that people fall into, as well as tax pitfalls that people are not even aware of. And I'd like each of us to introduce ourselves, tell you a little bit about what we do, and from there we'll start the conversation. Braddock?
Great. Thanks, Josh. Braddock Stevenson. I'm counsel at Paul Hastings. I focus primarily on anti-money laundering and sanctions. Prior to joining Paul Hastings, I was with the Financial Crimes Enforcement Network, or FinCEN, for 12 years, and most recently being the deputy of FinCEN's Enforcement Division before moving into private practice.
Hello, everyone. Steve Dowdell. I spent 11 years as a federal trial attorney, 5 years with the United States Department of Justice doing taxation work, and 6 years with the FTC doing consumer protection enforcement work.
Hi, everyone. My name is Nicole LaFaz. I am a crypto attorney, got my own practice, and my specialty is to help you reduce your liability exposure and try to avoid government backpush.
My name's Clinton Donnelly. I'm the president of Crypto Tax Audit, and we specialize in tax return preparation for high net worth clients, but we also offer a service now where we defend people in audits before the IRS. Nobody's done as many IRS crypto audit defenses as our company has, done 40, and we now have converted into a monthly subscription service like insurance for your tax return. If the IRS audits you, we'll defend you no additional charge. So I think I got some unique perspectives in terms of how the IRS is pursuing crypto investors.
And I'm Josh Hale. I'm the face of Non-Fungible Counsel and also podcasts and a couple other things, as well as being a crypto attorney myself. And I represent a bunch of different projects in the space, including the event that you're at right now, Dcentral. So thank you for being here. And basically, I'd like to kick this off just with a really simple question for each of you to kind of give a little bit of, real world practicality of what pitfalls have you seen that your clients have went through that you can speak about, obviously, that are things that should have been easily foreseeable to an attorney, but wasn't so much foreseeable to the client.
Thanks, Josh. I think the big one that I'll probably start out with, and it's one that there's even news about today, is sanctions. I think the biggest issue with cryptocurrency, or a big concern with cryptocurrency, is you don't always know who your counterparty is, and the fact that you are on this, kind of global scale means that you can be transacting with persons located in comprehensively sanctioned jurisdictions pretty quickly. I think even today there was a sanctions issue, enforcement action against Kraken for I think $380,000 for only $1.7 million worth of funds. And so I think that was a high penalty, considering that you would not expect them to be making that much money on it. And so it's really, you need to be doing IP address searches. You need to have solutions in place to ensure that whoever's on the other side is not located in a jurisdiction subject to sanctions.
Clinton, you're seeing stuff in a slightly different way because you're representing the tax side. What are some issues that you've seen in the world of crypto that, for you, had your client just asked a question, would have been a pitfall that you would have said, oh, no, you got to take care of that. You got to do this. You can't do that.
Come on, man.
Well, we can tell from statistics from the IRS that approximately 80% of all crypto traders are failing to report their crypto income, either in part or even file returns altogether. This is a big issue. I would say a couple of things that jump out to me is that under the tax code, under section 6001, you are responsible for having receipts of all your transactions. And if you walk away with one thing, remember this: in an audit, the blockchain is not your friend. And especially in the trading of NFTs, we do not have adequate documentation to explain, how did you get that NFT? And you say, well, a couple days ago I sent some ETH off to some address, and then this NFT arrived from some other address. They're not connected, they're not linked, you don't have a receipt, you don't have a documented paper trail. In an audit, the IRS has the privilege of treating that all as income and taxing it. So this is, the biggest thing would be for people to capture screenshots whenever you do a trade. Keep a running journal of your trading activity. I transferred money from MetaMask to Kraken. What was it you transferred? What was the date? Keep a log. These are these basics that you could do to help to protect yourself, because the IRS is really, really revving up for enforcement on crypto traders.
What about you, Nikki?
So I deal a lot with startups, and the first thing that any startup company is fearful of is, what taxes do I pay, and how do I pay them, and how do I keep track of all the transactions going back and forth? And honestly, it turns into a somewhat scary situation, because people don't realize that you get taxed by either trading coins, by buying and selling an NFT, by flipping NFTs, by having airdrops, by gifting an NFT to someone else. So these are all very tiny transactions that in the lump sum, they can be very burdensome when it comes to filing your taxes. And some people just don't file them all together because they don't want to start looking at their transactions like, did I lose? Did I gain? Is it capital gain? Is it a loss? How do I file it? Under what circumstance? And then all of a sudden, you have the IRS auditing you because you have a wallet. And you've had a series of transactions where it doesn't match what you're filing with what you're making. So that's one of the things that every startup company should be focused on is you have a clean slate. You're just starting up. So if you're clean from the beginning and you keep this track record like you mentioned, it's a lot easier when you're now a big company and you're making a lot of money and fluctuation is just coming in like no one else have ever seen before. So once you're big and once you have a lot of money, it's going to get even harder than it is when you're a startup.
So, Steve, you did FTC enforcement, and you were seeing it on the other side, and Braddock worked for FinCEN as well. What sort of things did you see as part of enforcement actions that you're sitting there going, boy, this guy obviously did not talk to a lawyer?
Yeah. So I think with the FTC, it's America's largest consumer protection organization, and that's fraud, that's unfair and deceptive practices. Here's what I've been thinking about with that. Like, there's the NFT community out there, and it's a good community, and nobody likes the rug pullers out there. The FTC has the biggest database in the country for consumer fraud, and right now the NFT community is trying to find a way to figure out when they're going to get regulated and when they're not, and it's kind of like a game of whack-a-mole and just kind of waiting to see when the government's going to come in. So my idea is like proactively kind of forming the NFT community's own database where you can report these rug pullers anonymously. And as an NFT community, kind of in like a Web3 space, like support this database and then share it with the FTC. So when the FTC comes in, they're not just whacking the whole NFT community, they're whacking the bad people, and the NFT community is actually helping them out.
So this idea of whack-a-mole that you're talking about, where people are, right now, it's really hard for the agencies to really have an idea of what's happening. Do you, based on what you're saying, if you had to give it advice on somebody supporting and obviously it's not legal advice, guys, but if you were pinned under and said, would you advise a person to look at a project that has been doxxed versus not doxxed? What would your gut reaction be?
I mean, it's really hard because there's no precedent in this space. The FTC hasn't really brought in enforcement action against an NFT yet. So what's my advice? It's kind of, lawyers give kind of dumb advice, because we don't want to be wrong. But don't get caught. Don't be the worst, right? Point the finger at somebody else.
I would not take that as legal advice.
There's very little to give on this particular field with the FTC. Yeah, we can move on to the FTC. It's no good. not in this for this conversation.
Apparently, the FTC is no good. You might want to not take that as legal
I mean, this is the problem with the crypto space is when you don't have any precedent whatsoever, who knows what's going to happen? For like the money laundering space, there's been a lot of enforcement action, so there's a box to draw where you're definitely, outside the box and you're okay. You're definitely inside the box and you're not doing very well. But the FTC hasn't really brought any consumer protection actions against like an NFT space. So who knows what they're going to do the first time around? I mean, that's my point is it's so up in the air.
And I think a big thing there, I mean, if you look at, the executive strategy on how to handle cryptocurrency that, the Biden administration has put out, the CFPB has contributed to that, strategy even when they weren't asked to. So they're proactively involving, and CFPB kind of works in the same area as the FTC in terms of consumer protection, but focuses on financial institutions. So I think this is something that is a risk that's probably near term to, like, it wasn't necessarily a historic risk, but these consumer protection issues are ones that are going to be near or midterm in terms of a first enforcement action in that space.
So Braddock, you worked for FinCEN, and you're now outside of that space. You helped draft some of the laws that are currently being used for like money laundering and some of the issues that we're seeing in crypto right now, like what you were talking about earlier, that there was a action for Kraken and Iran. Can you explain a little bit more about that and why it matters to maybe John Q. Public?
Yeah, and I mean, I think, it's partly it matters through, at least the U.S. government sees it as mattering through John Q. Public because sanctions kind of, allow them to put foreign policy goals and foreign policy issues out there in terms of who should be able to do transactions with the United States, to make sure that they can establish what types of activities they support and that they're not going to support certain regimes or certain jurisdictions. For startups and for people who are doing these businesses, the issues that come across is OFAC sanctions in particular is strict liability, right? You don't have to demonstrate that the person knew that they were transacting with the wrong counterparty. You don't have to put anything about willfulness in there under a civil context. All you have to demonstrate is that somebody transacted with somebody who's located in Iran, located in North Korea, there's Ukraine, Luhansk, or Donetsk and Luhansk areas of Ukraine, so not Ukraine total. And once you establish that, the government kind of has its case. And so then what they're going to look at is, did you have a system to try and detect it or not? If you didn't have a system, then it's going to be considered an egregious penalty, and they're going to take the maximum penalty. If you had a system, then they're not going to be taking the maximum. And I think a good thing to understand is, the maximum penalty in the action today would have been $274 million, and they only took, I think it was $380,000. So it's a substantial discount.
So that goes back to my question that I asked Steve before about working on going and investing in an NFT project of which is doxed or not doxed. A NFT project that's not doxed, you don't know the countersigner, you don't know the other party. And while Steve is from a CFTC point of view saying, no precedent, maybe not a problem, from a FinCEN point of view, they're sitting there and saying, well, maybe this new board animal that you are really interested in, the party that you're contracting with is a party in Iran. And I would guess, and I don't do this aspect of the business, but I would guess that if you're buying into a NFT project that's not doxed and you later find out that it's going to a sanctioned wallet, that even as John Q. Public, it's a problem for you.
Yeah, I would agree. Even as John Q. Public, it's a problem, especially if the values are significant. That's where you're going to get the most scrutiny.
So, on your end in the tax realm, Clinton, you have obviously seen. You said 40 actions that you've defended, and what is the biggest area that you see people misreporting? Or what are you seeing in the tax realm that is causing this to happen as much as you see it?
The primary reason that people get audited is because the IRS is aware of more income than you reported. They learn about your income through a W-2, a 1099, K-1, but now they also have information from most of the U.S. exchanges, and they can simply look at what's the total amount of sales that you had, and did you report on your tax return the amount of sales that they see. This is the easiest way for them to come after that. If you want to get audited, that's a good way to get audited, is to underreport your sales. When I think about the changes that I'm seeing in the IRS right now, they're doing the same thing the other U.S. agencies are, which is basically regulation by enforcement. They're just pushing their perspective on the law, and they're saying, take us to court, see if you win. And they're being very aggressive in fighting those things, and they're not bothering to explain how taxation has happened. I think two things that most taxpayers are greatest at risk are in the area with NFTs, particularly with DAOs, is I do believe that a DAO has a very high likelihood of falling underneath the PFIC rules, the Passive Foreign Income Corporation rules. And the taxation regime on PFICs is basically, and it's very egregious. It runs roughly 40 to 60% of your profits averaged over 3 years. So it's a very harsh penalty. I expect the IRS to start doing enforcement on that, and they'll say, take me to tax court, prove me I'm wrong. The second thing that I think everybody has an issue with is in the foreign reporting. There's two foreign reportings. One is the FBAR, which falls under FinCEN. The second one is a Form 8938, where you have to report transactions. The law says in Section 6038D, it says you have to report any financial instrument or contract for investment purposes where the issuer or the counterparty is not a U.S. person. A DAO would definitely be not a U.S. person unless it was incorporated in the U.S. So all those things would have to be reported. Failure to report on this form, once the IRS recognizes that you should have filed the form, this is where it gets scary. Once they recognize it, the statute of limitations clock is reset for 3 years after you file the form. Okay. Secondly, once they find out you should have filed the form, they issue you a letter with a $10,000 penalty. This penalty increases to $50,000 over 6 months. Furthermore, any income that you didn't report that should have been accounted for on this form, you're now subject to an increased accuracy penalty of 40%. And I've not seen the IRS play this card yet, but they have not played all their cards. This is big. So what is I'm kind of interested in Braddock's opinion because it overlaps with the FBAR filing is, would a DAO be a non-U.S. entity? Do we have foreign filing obligations if I'm trading on, say, KuCoin, a foreign exchange? This is a gray area, and I think the IRS is going to take a very aggressive position and hit people with it. Just recently, they opened up so that the agents can actually see the FBAR reports much more easily than they have in the past. So I think the reason this is scary is because in an audit, we're going to argue over how much your gain was, and it's complicated, and intelligent people will disagree. But it's very black and white whether or not you reported an exchange. It's just black and white.
Yeah, Clint, I think that's spot on in terms of the definition of person is very broad in Title 31 actions, and as the CFTC as well has a very broad definition, which includes unincorporated groups and unincorporated associations. And you look at the definition of a money transmitter, that definition is any network of people that facilitate a transaction outside of the traditional financial system, and a domestic financial institution or domestic money transmitter is any institution that conducts an action in the United States. So if they wanted to, they could really fit a DAO in there, which I think is a pretty extreme position to take, but that doesn't mean that they won't do it. The other thing that brings, that you brought to mind is the fact that all of this happens administratively. And there's two cases going to the Supreme Court right now, one involving the SEC and one involving, I think it's the FCC. And those are about, do you have constitutional challenges in administrative hearing? And historically, the answer has been no. But some of these questions about where the government has information that they haven't provided you, which rings due process concerns, right? If the cases rule the way that they're expecting to, there might be abilities to put more challenges on the front end instead of having to wait to go through the tax court before you can actually challenge what that process is.
So one of the issues here, like I was speaking at a conference in Dubai last year, and I would hear regularly the people that I was talking to in Dubai that we're not American, right? And there's a lot of what we're talking about right now is very, U.S. American-based thought process. Nicole is licensed both in the United States and in Honduras, and when you're advising clients that are coming from the United States and coming from Honduras or elsewhere, does your advice differ? And if so, can you give us an example?
Sure. So a lot of times clients ask me like, okay, what about if I operate overseas? What about opening my corporation overseas. That way I don't touch U.S. soil, and I don't have to deal with regulations, SEC, or tax implications. And my question is like, sure, but are you targeting U.S. market? Like, is any of your customers hitting U.S. market? And the likelihood is that they are. So if you're hitting U.S. market, doesn't matter where you're incorporated, doesn't matter if you're not a U.S. citizen, you still have to abide by U.S. law. And this is it comes down to that, right? What market are you targeting? What is the pool of clientele that you're looking for? So say if you operate in Honduras and you're based in Honduras and all the market that you're reaching out is Central America and South America, then you're good. But if you do touch U.S. soil by some reason, any of your clients that you do not know of is in the U.S., you're still on the hook for that. So this is something that it's a matter of doing due diligence, like cleaning up the house, making sure your house is in order, and making sure that you're doing and abiding by the law that a lot of people think it doesn't exist, because there's a misconception that because you're in a blockchain in Web3, you're jurisdictionless, or you don't have a specific location or a specific law to abide by. And the reason being is because of the lack of knowledge. So, is coming to this type of conferences, mingling with attorneys who are in the space, and at the end of the day, you have to abide by every single jurisdiction that you're marketing to. So if you're marketing to Dubai, to Honduras, to the US, you have to abide by all three jurisdictions, and most likely file taxes in all three jurisdictions as well.
It's interesting when you talk about having a client that you don't know about in the United States. It's the idea of like availment versus purposeful availment. And I'm very curious, from the two guys that used to be on the side of the government, how you guys see the idea of, is there a legal issue in the idea of availment versus purposeful availment? Is this business purposefully availing themselves of the United States, or is this an accidental availment? And is it an even legal issue, or is it strict?
I'll start her.
The term strict is with a lot of, I was going to say a lot of the stuff that Braddock's talking about, but I'll just let Braddock talk about it.
I guess the one point, at FinCEN, and I think to this point, is it's a should have known standard. So I think it's somewhere in between purposeful availment and availment. If you happen to have customers in the U.S., could they look at that and try to apply jurisdiction? Potentially, but in the enforcement actions that we've seen, it's been institutions that should have known or knew that they had U.S. customers and then didn't do enough to remove those U.S. customers. If you look at the BitMEX action, they were operating in the U.S., they knew they had U.S. customers at the time, and then when they closed everything from the U.S., they knew that they were continuing to have logins from IP addresses in the U.S., VPNs from customers that were previously located in the U.S. and hadn't updated their address information. That all existed on the platform. So that's you should have known, you didn't do enough to stop it. And so that's where you're going to have your enforcement action. And if you look at the iFinex action out of New York State, you had members of the management team were located in New York. You had multiple touch points with New York that established that you had those touch points with the U.S. So maybe it wasn't, we were catering, we were marketing to the U.S., but we knew that we had U.S. business, we knew that we had U.S. touch points, and we didn't do enough to mitigate that or to prevent it.
So my experience with the FTC is, so we're civil law enforcement. Like, Braddock's people can send you to jail, and we can just take your money. So our jurisdiction is federal courts, and I'll say that the overseas actions for us, we didn't have all the cool toolboxes that a lot of the criminal law enforcement types have. We relied on the court's power to issue orders to freeze accounts or whatnot. And a U.S.-based court only has jurisdiction over U.S.-based financial institutions. So I did a couple enforcement actions in Canada. There's a couple Latin American countries. And I'll say that from the FTC standpoint, we didn't like to get involved with those cases from a consumer protection case because we couldn't win. We couldn't really get an order that would make assets that were overseas come back over without a lot of help. And in that case, that agency just didn't have that offshore help to act as like a hammer. With some of the more criminal stuff, it's like, well, they can say, we're just not going to do business with this bank anymore. And this bank is going to hand over everything they have for your suspect. When you're dealing with like a U.S.-based civil court, we don't have that power. So you definitely want to kind of take into account what action is going to be brought against you and what their jurisdiction is versus what your level of exposure is going to be.
With that being said, guys, I assume each of you have some sort of social media or a way for people to reach out to you. Clinton, how would you like people to reach out to you if they're interested in talking tax and doing what you do?
CryptoTaxAudit.com is our website. You can buy our monthly subscription there, and there's lots of services. If you want a direct consultation with me, there's a button up at the top, request a consultation, and we can schedule one. It automatically schedules, and we'll talk.
Nikki?
For me, I use my LinkedIn as my Outlook. It just turned out that way. You search for my name, or at Twitter, Black Swan ESQ.
So for me, it's also LinkedIn, Steve Dowdell, and Twitter handle is Steve D is Steve D. That way you can find me.
Yeah, I'm also on LinkedIn. It's Braddock Stevenson, Stevenson with a V.
And you can find me pretty much anywhere, guys, under this, that, Josh, as well as on LinkedIn. You can actually search that as well, and make sure you press the search button, and it'll take you right to me. Ultimately, thank you for listening to Implications of Tax, Pitfalls, and, attorneys talk boring stuff. Thank you for being here, and we appreciate you being in the audience.